call our next case, which is Timika Rayford versus American House Roseville, LLC. This is a full grant. Each side will have 30 minutes. Again, you'll have a 2-minute free fire or fire-free zone that you may waive. And Ms. Akins, if you wanted to reserve any time for rebuttal, just we ask that you keep track of it yourself.
Okay, thank you, Your Honor. I would like to reserve at least 5 minutes for rebuttal.
5 minutes, okay.
Thank you.
All right, and whenever you're ready, you can begin.
Thank you. Good morning, and may it please the court. My name is Carla Akins on behalf of Timika Rayford and really the citizens of the state of Michigan. I know that you've asked me to answer 2 questions in submitting this case, and I think it's important to note just the overall tenor of what's going on in employment law. So there's a rule of law, but there's also summary judgment, motions to dismiss, things that have eviscerated the 7th Amendment, Article 1, Section 14, right to a jury trial. And I think that these types of traps that are set are unfair to plaintiffs. Most people, if I tried to explain to a non-lawyer yesterday what I was doing today, and they don't understand. They don't understand, what do you mean they can do this and what do you mean they can do that? Because nobody ever anticipates at the beginning of their employment or even before then they apply that they're going to one day have to sue their employer for sexual harassment or racial discrimination or disability discrimination, and that the law that says when they Google, because they're going to do that and look it up and say, oh, it says 3 years, I have 3 years to sue. And what happens in this, which is special to the employment context, is it's very difficult for people to come forward right away. A lot of movement happens in that time frame of that 3 years. You have people who are managers who are getting let go of. I file a lawsuit. A lot of movement happens after I file the lawsuit. There's just time that has to happen. And there's just not that many of us. There's not very many employment law practitioners. We've lost one of you to the bench, fortunately. But it's not that easy, and there's a reason for that, because the law has been so unfair to employees. My phone rings off the hook every day with people calling, needing assistance from their employers, because it's unfair. The landscape is already unfair to begin with. I think the fundamental issue that we have is that Rory, I think it assumes that there's like equal footing and everybody's coming in with great intentions. And I will tell you, the beginning of every employment case starts with somebody not telling the truth. And I know that it becomes difficult because in the context of summary judgment or summary disposition in the state, but your opinion is going to matter obviously in federal court, because a lot of cases are waiting. Every single week I have to argue this case. Yesterday, I had to argue this case at the Court of Appeals. Just hold on, just wait and see, because I think that maybe hopefully there's going to be a change that's coming. I think that nobody thinks that they're going to have to one day do this, they're going to have to one day be here, and I think there's this idea almost embedded in law somewhere along the way that plaintiffs were coming in for petty reasons and contrivances and things that didn't really matter. And then you're looking at almost 100% summary judgment rate on cases these days. And it doesn't make any sense, because people will say to me, well, how can that be? I thought I had a right to a jury trial. I thought that, how are they filing a motion to dismiss? I don't remember signing this document. And even if you did, do you know what it says? The last time I was here, we talked about sophistication of the people. So maybe you had a lawyer who was there. But I can tell you, I'm friends with a lot of attorneys, even plaintiffs' lawyers. And they don't know what arbitration is if they don't deal with it. So I'm jumping around with respect. I know you're holding a couple of cases in abeyance here, but it involves a fundamental right that's being taken from people without their knowledge.
Can you sort of talk to the issue? I mean, not even if some employment contracts may be properly viewed as adhesion contracts or unequal bargaining power. Obviously, there are some that are negotiated. Is there a difference? How do we craft a rule making a distinction between those? How do we make a rule that differentiates between contracts that or these terms that are agreed upon before accepting employment, as opposed to, you know, boilerplate signing it on the back of a handbook after, you know, they've now been employed and started receiving benefits for 30 days, whatever it may be? Help us sort of craft the rule of, or is it your position that anything regarding employment needs to be carved out?
Well, I mean, I think the precedent has been set in the cases that you all cited in accepting the case, in Herwire, and even in the dissent in Rory and Justice Kelly. I think Tom Thomas, I think, was the first one that set out, you know, you need to look at reasonableness. And then you got Camelot, okay, well, we're going to look at reasonableness, and then all of a sudden Rory comes along, and now we're not. Do I think that there's a special category for employment? Absolutely. There's under no circumstances is there an equal bargaining power. It just doesn't exist. And I think in terms of, to answer your question about how do we fashion a law, I think in this case we're talking about a statute of limitations that's already something that's established. And Justice R, I listened to the argument before about, are we putting Constitution online with a statute? But you have statutes and you have a Constitution that says you have a right to a jury trial. You have 3 years to file a lawsuit. If you have things that are contrary to law and you're allowing, in a situation where you know that this is not balanced, and you're allowing that to persevere, I think you have to intervene in that case. And I think that's what Justice Kelly and Justice Levin was saying even in the concurrence.
But is that, I guess that's my point, is that you have to recognize and you have to intervene in a case where you know that, where there is unequal bargaining power, because it's not true in every employment context.
We're dealing with, I think, like the boilerplate.
I mean, is that what we're
assertions?
talking about? Like, how do we, I mean, again, what we're looking at is how to craft a rule, not for this case, but for the next cases to come. And what sort of should that rule be, in your opinion?
Well, I think that I think looking at it from a reasonableness standpoint is the right way to start. I agree it's difficult. I do understand that there might be situations where both sides have attorneys and they come to the table with, I don't think it's ever going to be equal. I mean, you come with me and then whoever else the corporation has, which is usually going to be 4 or 5 other attorneys or whatever. I think I understand the concern, but I do think that we have to do it. We have to figure out what that line should be. And in my opinion, I think it's, at the very least, at the bottom, it's where the law says otherwise. We don't let you contract around the law. We don't let people do that in the criminal context, because you say, okay, well, give me the right to assault you. We wouldn't let anybody do that. And just because now we're in a civil context, we're saying, well, it's okay because, even in our Constitution, we're allowed to waive the right to a jury trial, right? You still have to assert it. But I think in MCR 2.508, it says the jury trial right is inviolate. I don't know of any other stronger language that's used in the court rules to tell us that when you have something that's fundamental to, it shouldn't be disturbed, inviolate, shouldn't be bothered, should not be violated. That means that you're now dealing with fundamental rights, and we have to draw the line somewhere. I do agree. I thought about this because I figured someone would ask this question. Where do we draw the line? Because I thought about it, when we first talked about this, I think it was in the civil rights context, right? Now I'm looking at the question, I said, well, they're talking about in the employment context, period. It becomes a bigger question, especially for Ms. Rayford, where she had abusive process claims that were stricken and malicious prosecution claims that were related to the employment. I think at the very least, the floor is the law says something else, and then we're not allowing in a contract of adhesion situation for them to contract around that. I mean, you've got lawyers before, the lawyer drafted the document. I mean, so many things have happened in the 2 years since I've been here.
So Counselor, can I suggest there might be two ways of viewing a reasonableness regime? One is sort of a fact-based inquiry that looks at, do the rights that are in that contract, does it just affect one party? And so maybe that might suggest that there's something imbalanced about that, or if it's boilerplate, we would sort of look at, a sort of set of common factors. to decide that reasonableness. Or there might be a reasonableness regime where you're saying it's not reasonable unless it's the sort of statute that, sort of the backstop statute of limitations statute. Which of those reasonableness regimes are you suggesting is the right one?
Okay, I'm sorry, I'm having a little bit of a hard time
So
hearing.
one is a fact-based inquiry. Is it a boilerplate? Is only one party giving up rights by this contract? You know, sort of looking at those sort of factors that occur
Sure.
in a number of cases. The other is just saying reasonableness means the legislature has a backstop statute of limitations, and that's what's reasonable, and that sort of ends the inquiry. We're not doing this sort of nuanced inquiry. Which of those are you suggesting?
Probably something closer to the latter. I don't think that going into, I think that's what everybody, well, that was what I was about to say actually kind of dovetails into this. So the McMillan case, they said, you all said, excuse me, I've been saying they for so long with all these arguments. The Supreme Court said that it was supposed to be a question of fact. And then what happened? I don't think I had one case where they found that it was a question of fact because some other procedural issue came up, or you didn't say in your declaration that you didn't understand it, or saying you didn't understand it wasn't enough. So if you're going to go into that type of factual inquiry, I think we end up at the same place. And that's why I think you have to go a step further and say there is no set of circumstances in which, certainly in my client's situation, an hourly worker comes in and she'd already started, and then they give her this quote unquote, it's never an agreement, right? It's always called something else or some policy or something, and then they want to make the person agree to it. And I think Justice Wells, we went into this the last time about, well, when does the contract start? What did you actually give up? If you've already started working, is it a contract? What are you, employer, actually tied to? Because the whole concept of a contract is a bargain for exchange. So I think if we get into that type of, well, that's why we ended up here. If we go into that level of analysis about what happened in that specific situation, I think we have to understand that it's never fair. It's never fair. It's always unbalanced. I mean, I had a case where, and I know there's people watching and probably wondering, am I going to bring up their case? This one I am. There was a case I had where we were in the middle of litigation and my client was given an arbitration agreement. Had the law firm's name at the bottom of the agreement, and they wanted her to sign it. Somebody else said to her, you maybe should not do that and then give this to your attorney, so I got it. And, I confronted them about it because I said, well, look, we're in the middle of litigation, and the firm is communicating basically through HR, which is what happens in most of these cases. I had a deposition a couple weeks ago where I think for the first time in over 10 years, I heard an HR person say that they work closely with the legal department. That's the issue. They have law firms that support them at every step of the way, including before the person even gets there. And my argument yesterday, I didn't notice it until I went back and looked at the video, but there was like 3 partners at the Court of Appeals. One of them argued, and a couple others who were sitting behind me, and then it's me, And it's not about numbers and how many people. It's the fact that you have a lot of people who are invested in trying to make sure that these things get protected for the employer before the employee ever has a chance or even understands what it is they're talking about.
Can I ask you, assuming we were to agree with you about that reasonableness should play some role, and say we agree with you that Clark should be overruled and that Rory should not have been extended into the employment context, would we, in order for your client to prevail, would we also need to overrule Timco, and where Timco said that a 6-month statute of limitations is reasonable?
I think so, just to the extent that we're picking times for reasonableness, kind of to what Justice Thomas is talking about. If we're going to go into the specifics of how it's reasonable in a particular situation, I think that's where you run into the problem, right? It's that if we already know that this situation is by default unfair, never fair to the employee, never balanced in a situation where, and including Ms. Rayford's situation, I've had that happen a few times where she requested a copy of her employment file, and then they come in and they don't give it to her. And then even I asked, and we've sent a demand letter, and we still didn't get it, and nobody raised this issue, and then you come into court, and now, the time's up, and so now we're at a situation where I've had that upheld on numerous occasions, where I said, how can you let them wait until the 6 months ends to come in and say that you had a contract? That happened in McMillan. I think we found out well after it was 9 months, I think, in that one. So yes, because I think that you have to, I think that's what the court's supposed to do, is to look at, I think the comment, I think, from Justice Young and Rory was that there wasn't any precedent for basically taking reasonableness into account. But that is not the case. I mean, you look at, like I said, Tom Thomas. There was cases before that, Herwire. You can do that. I don't think that there's any, certainly not harm in doing it, but at the same time, you're always going to be making some type of an inquiry about whether the person understood it. So why would you not take reasonableness into account as well?
Counsel, so if there is this reasonableness component, we were to agree with you that Clark was incorrect as to Rory, what is the line then? Is it always just whatever the default statute of limitations is, or could it be a year? Could it be 2 years? I mean, it starts to sound more reasonable the more time someone has, because I understand your argument about the short period of time that's hard for an employee to get their act together, get to a lawyer, get a lawsuit filed. That is, there's some merit to that argument that that's not a very long period of time, 6 months maybe, whatever it is. But is a year enough? Is 18 months enough? Is something else reasonable?
I don't think so. I mean, I guess when I look at it, I'm thinking again in the criminal context. I can't imagine a time when you would agree to something that would violate your rights and you don't even know that you've done it. And I've never had one person actually understood that that they signed something to this effect. And I think you have another case of mine, Best Buy case, and Johnson versus Best Buy. And it's a e-signature now because there's no paper. So you're throwing this into a stack of papers, but now it's a virtual stack of papers, and you're just clicking through a screen. And now we need to try to figure out what the time is. I don't think you can have a situation. That's what we've had, right? That's what those cases stood for. Is 6 months enough? Is 9 months enough? McMillan is a year enough? And I think if you continue to do that, we're going to be here all the time trying to figure out, and not necessarily in the Supreme Court, in court trying to figure out what's reasonable. I don't think that that's what we should be doing. I think that, the statute says this is what the time period is. I think that we should abide by that and not allow what I thought was that we were not going to allow an employer to set another time. I mean, it's the entity who's doing the discrimination, the entity who's violating the person's rights gets to choose when and how long it is that they get sued. I can't understand a world where that sounds fair to anyone.
So we obviously allow it in lots of contexts, though. Clearly, Rory was in the insurance context. Why is it different here?
Well, I don't think Rory was correctly decided either. So I want to be clear about that. And then I think Justice Kelly addresses this. So, I'm sorry. When Rory talks about it in the insurance context, and then the insurance commissioner came in and said, no, we're going to do 3 years, none of this 1 year stuff. And I'm sorry, it was Judge Neff, I believe, at the Court of Appeals, my apologies, who said, well, we don't have that here. We don't have an insurance commissioner who's going to come in and change the things. And there's no lobby for employees who are hourly workers who come in here and try to say, you know what, we should change the statute. They don't even know that they need to. Like I said, if I tried to explain this to somebody who is not even an attorney, even the ones who are, they don't really understand why it matters to them until this type of thing happens and they have to explain to them why their case got dismissed. So I think it's inconsistent to have it be whatever time that you want it to be. It needs to be the time that's set forth in the statute because that's what the law is.
What about the argument that I fully expect from Brother Counsel that the statute, we have to use the default statute on the statute of limitations, that it doesn't have a specific statute, a time period set in there, and in other employment contexts, there is language with specific time periods?
Well, I think I believe we had discussed this in the prior argument, which was that that's been upheld. It's 3 years, everybody understands that. I think if we're talking about causing something that's gonna cause problems, it would be saying that it's not 3 years now when everybody has been saying it's 3, and then you have people who are obviously relying on that to file new cases every day. So that's been, the precedent is already that it's 3 years, even if it's a default. I mean, that they had an opportunity, if you want to talk about the legislature, had an opportunity to make it a different time like we have in medical malpractice, things of that nature, whistleblower, 90 days, things like that. But that hasn't happened. We've accepted that it's 3 years and that's what it should be. Any other questions, or should I continue on? Okay. So to address the questions that were asked here, I just want to kind of go through the progression of the cases that led to this. And I think that, as I said, I think that Rory was incorrectly decided, because I think that's where things kind of got awry. As Justice Kelly said, this has been, it was going to take us, I'm going to get the direct quote from her, that doing what they did here, so the choice made by the majority regresses our judicial system by decades, if not centuries. It places the state back into the era when courts either used covert means of interpreting contracts or ignored equity altogether. And that's been 20 years. And so we're back here, and I think the time has come for us to take into account that these things are not reasonable. I mean, there's no protections for employees. And then unfortunately or fortunately, I mean, these things happen all the time because everybody works, right? We end up, that's why I get all of these calls, because people have problems with their employers. I think that if you don't intervene here, we end up with this landscape where you just allow, you assume, and the law assumes that, again, everybody is on the same footing and everybody's telling the truth and everybody has great motives,
Well, but that was the case when Rory was decided. It was the case year one after Rory was decided. As you say, we're 20 years in. Why, and you say now is the time to do it. Why is now the time to do it?
Because it just, so to the point that, and I think this was Judge Neff, I want to make sure I get it correct. There's a few dissents that I was looking at. And it talks about, I think it was Judge Neff, because she says in Clark that if we continue to do this, then everybody's going to be putting these statute of limitations into their contracts, and now everyone's going to be out of court. And it kind of goes to the same thing with the Sadazan case that you all are holding in abeyance. Once you start doing that, nobody's in court anymore. We're here for justice. This is not a private contract situation. This is a public issue. You're talking about civil rights. You're talking about employee rights. And if you are able to allow them to manipulate the landscape in this way, I think it's apparent to me that it's picked up, right? So I'm seeing way more arbitration agreements, motions to dismiss to compel arbitration. I probably get them weekly now. Less so of these statute of limitation ones, but those are still around. And certainly for certain employers, I don't know why everybody hasn't done it at this point. Maybe just because if too many of them did it, then they might say, well, no, that's a problem if everybody's having to go to arbitration, or everybody has to skip the EEOC, and everybody, because the MDCR, Michigan Department of Civil Rights, you have, 300 days to go to them. You've got 300 days to go to the EEOC. If you're allowing this lesser time, different times, I think it's just confusing. I think that, I can't say because I've only been practicing for the time period that I have, not since Herwire was around, but in the time period that I've been practicing, I definitely have noticed a pickup in motions to dismiss being filed at the beginning of complaints. Right after we file the complaint, everybody wants to extend the time to answer just so they can file a motion to dismiss 12B6 or under state law. So, I think that it's gotten to the point where, I think we have the opportunity to do it. You all have asked us to come up here and argue it.
Can I ask you
Yes.
just a hypothetical?
Sure.
Say a prospective employee goes through an interview and the employer comes back and says, we like you, we'd like to offer you employment. We can do an at-will employment where you can be terminated for any reason or no reason as long as it's not inconsistent with Michigan law. and we'll pay you $21 an hour. Or, here is our employment contract, and if you're willing to sign the employment contract, we'll pay you $21.50 an hour. Take it home, think about it over the weekend, let us know what you decide. And the employee then signs the $21.50 an hour and brings it back, and it has the 6-month limitation in there. Would that be valid?
I would argue that it's not under the law that I'm proposing, because I think it's the same situation, right? You're taking advantage of people at their most vulnerable time. They are looking for a job or have a job. In Ms. Rayford's case, she had her job, but she's supposed to quit her job because they handed her a document she didn't understand.
So then, if that's the case, that that's not valid, then what contracts are valid where there is a difference in bargaining power?
Respectfully, I don't think we don't have to go that far. I think in the employment context, you have precedent already for the idea. Insurance, I think, is one of those other areas where you're given something, a contract to sign, and you don't really have a lot of bargaining power. I think just the concept that we need, like Justice Kelly said, you just need to be more careful about considering those things at the very least, and maybe there's a heightened level of scrutiny that happens in those situations, not that you're going to invalidate all of them. But in this particular context, you throw people 50 more cents, yes, they'll sign the agreement, probably 100% of the time.
If it was instead of a 50-cent difference, a $5 difference, would that be valid?
That's what I'm saying. I think anytime you could give people a quarter. I get calls for those types of things all the time. People are in unions. They get paid a quarter more, they were denied their quarter more. Those things add up for people. So I don't know that there's a bright line, how much money is enough, or I think it's the whole concept that if you're dangling this carrot in front of people and they have no concept of what is on the other side of what's happening, what happens, because no one goes in expecting, well, you know what, I'm gonna have to sue my employer for, like, again, sexual harassment or something along those lines. That's just not something that people think about.
So the party in a lower bargaining power never has the opportunity to accept whatever that offer may be. The courts know better.
Say it one more time, sorry.
So the party who's in a lower position of bargaining is always going to be denied the opportunity to accept that 50 cents or $1 or a quarter, whatever it is, because courts know better than them. Is that essentially the rule of law we're going to make?
No, I don't think that denying someone the opportunity to have more money, but I think what we're trying to say is that if you're attaching some unconstitutional and or unreasonable string to what it is that you're offering, we're not going to let you do that.
And the unconstitutional that you understand, what you're telling me is unconstitutional is limiting the amount of time that you can pursue your jury trial. You still have a right to jury trial if you bring it within the 6 months if you agree to that. But it's that the fact you can't bring it 6 months in a day is what makes it unconstitutional. Just so I want to make sure I understand when you say unconstitutional, that's what you're referring to.
Thank you. Yes, so the unconstitutional argument goes more to the arbitration. And the point is, both of these go in tandem, right? There's a limitation on the time and an arbitration clause, and then that whole thing takes it into arbitration. That's the unconstitutional part. I don't think it's unconstitutional to shorten the statute of limitations unless we're going to go take it all the way back and say that you have a right to a jury trial and there should be no statutes of limitations at all. That's not the rule that I'm arguing for. Could it be an infringement on somebody's right to a jury trial to limit the time they have to bring a case? Sure, but I'm not arguing that. I'm just saying that in this context of employment where you're basically taking advantage of somebody at a time when it's not just that they don't understand it. They have no concept and have no understanding of what it is that they are giving up. Like I said, most people don't even understand why I'm here right now.
I got you. You asked for 5 minutes, you're down to 1:50.
That's okay.
Just bring it to your attention.
Counsel, is there a difference between having no bargaining power and maybe having some bargaining power?
There is, but I don't think that in the employment context that really comes up because then you have to understand what it is you're bargaining against.
What if you're a mid-level manager and you have a lawyer and you have a contract and you negotiate the contract with your employer? Is that okay?
I mean, I think in that context you have more bargaining power, but again, the employee is the client, right? So they have to be the one to say, am I going to turn this down? The lawyer is not the one that makes the choice. I just tell them what their rights are. I don't necessarily think it's right, but I'm not going to tell you not to take a job because you had a 6-month statute of limitations.
Okay. But just to be clear, like, obviously the case here is we're talking about sort of what I believe Judge Knapp characterized as boilerplate language, and whether it's in an employment, I guess, the back of a handbook or an application or something like that.
Yes, well, yes, that's going to be most people. The people who are going to come in with an attorney are going to be far and few between. I can count on one hand the number of times that people have come to me before before signing an employment agreement.
Thank you.
Okay, thank you. I will reserve my 30 seconds for rebuttal. Thank you.
There you go.
Good morning, Justices. May it please the Court. My name is Daniel Waslowski, Counsel for Appellee, American House, Roseville. I've heard a lot today about unconstitutionality and waiver of jury trial rights and arbitration and so on and so forth. Just to be abundantly clear, as I'm sure this Court is well versed in the facts, the procedural history, and the briefs, this is not about waiving a jury trial. There's no arbitration clause at issue in this matter whatsoever. This is simply about whether employees and employers can contractually have the freedom of contract to enter into agreements that control the procedural, not the substantive, but the procedural nature of how potential disputes may be litigated in court, not in arbitration, in court going forward. No one in these facts or in the briefing in this matter is contesting that they are waiving their right to straight up bring a civil rights claim under ELGRA. Obviously, this case is of significant importance to employers and employees in the state of Michigan. Otherwise, we would likely not be here. I submit to this Court that if this Court accepts plaintiff's arguments, including those of reasonableness, judicial determinations of reasonableness, which were expressly overruled by black letter law that's now been established in Rory for approximately 20 years, that this Court will be improperly overruling years of binding precedent, contrary to rules of stare decisis, which it obviously should not do, and will be supplanting the legislature's determination of public policy with judicial determinations of reasonableness, which of course is expressly prohibited under Rory. We'll start with the first question presented in this matter, namely whether Clark versus Daimler Chrysler properly extended this Court's holding in Rory to employment contracts. And as set forth in the brief, I believe this issue presented, which the Court respectfully directed the parties to brief, is somewhat of a misnomer in that Clark did not extend anything. It applied Rory as it was required to do under principles of stare decisis. As this Court observed in Hoffman versus Birkeland, application of stare decisis does not require factual identity between cases. It merely requires whether the question presented is essentially the same. Now, moving back to Rory, there's three unequivocal principles that have been the law of the land in Michigan for some time. Unambiguous contracts are not open to judicial construction and must be enforced as written, number one. Number two, the key, I think what's of key issue in this appeal that's before your honors currently, a judicial assessment of reasonableness is an invalid basis to refuse to enforce a contractual provision. And number three, an unambiguous contractual provision shortening a limitations period is to be enforced as written unless there's two exceptions. Number one, whether it violates the law, or number two, whether it's contrary to public policy. So if you look back at Clark had essentially the same issue that Rory had, albeit in a different context. Whether a provision, a contractually shortened limitations period, whether it violated the law, the answer to that in Clark was no, or whether it violated public policy. The answer to that question is no as well, and I agree with both those conclusions of the Clark Court. So I think you have to start, and if you look at Clark, you should continue to follow the rule established in Clark and adopt as Michigan Supreme Court precedent, in my view. That's why I submit to the court. There's simply, if we look at the first prong, whether there's a contrary, whether the limitations period, contractually short limitations period is contrary to law, there's simply nothing in ELGRA that prohibits that legally. So I think we can dispense with that pretty quickly. I think the questions that have come up in the application for leave and have also come up in this appeal as well after the application for leave was granted was whether or not a contractually shortened limitations period that provides a plaintiff employee with 6 months to bring an ELCR claim violates Michigan public policy. And if you look at plaintiff's argument, as we see, if you look at page 7 of the brief, principal brief, as well as the arguments that you've heard today, it really comes down to it violates public policy because there's unequal bargaining power. I mean, plaintiff wrote, employment contracts often lack the mutual negotiations and balanced exchange present in other contracts. I have to, with Justice Zara's line of questioning, I think you have to step back and look, in what situations in life is there ever truly literal equal bargaining power? The answer is virtually none. Even for, the justices in the room, my fellow counsel, sister counsel, attorneys who have a skill set that enables them to have advanced knowledge of negotiations and knowledge of the law. Even lawyers are at a disadvantage when they're signing contracts to insure their home for loss of fire, earthquake, flooding, so on and so forth. There's really, when a home buyer goes to negotiate with a mortgage company, unless you're some absurdly high wealth earner, the home buyer is always going to be at a disadvantage with the mortgage company. Similarly, Judge Shapiro, we cited this in our brief, pointed out the insurance companies and insurer and insured, there's always going to be disparity in bargaining power. So I think if you accept plaintiff's fundamental position that an employer may have more leverage, a stronger footing in terms of a bargain for exchange of legal detriments, you're going to invalidate virtually all employment contracts. We're not just talking about a contractual limitations period. This court will be stepping into arbitration agreements, which I know is another appeal, but that's neither here nor there for the moment, non-competes, sales commissions agreements, compensation agreements, and where would it stop? Because if the inquiry is simply, well, the employer had more leverage, stronger footing, more resources, the employer is always going to have stronger bargaining power, and you're going to invalidate all employment contracts. I think that's absolutely untenable. And if you step back and look back from the practical considerations, if you look at this court's recent decision in Soaring Pine, the considerations of what are fair or equitable don't have a place in this discussion. And I quote, "The focus of the judiciary must ultimately be upon the policies that, in fact, have been adopted by the public through our various legal processes." So, in terms of what public policy support, whether public policy prohibits a contractually short limitations period of 180 days or 6 months, I think obviously you start with the Michigan Constitution. I mean, that's first and foremost for an ELCR claim, of course. There's nothing in the Michigan Constitution, nothing that suggests that limiting the contractual limitations period for a statutorily created cause of action, ELCR, violates Michigan public policy. I think this is a starting point. From there, again, we move down. The legislature. What has the legislature said in this context or other contexts? Well, in terms of this context, they haven't said anything about whether a contractual limitations period for ELCR claims violates Michigan public policy. And in fact, they're completely silent on it, as this court is undoubtedly aware. The default is the RJA, but as this court has held in Sam versus Bellardo, the 1981 case, the RJA is legislation that affects procedural rights, not substantive rights. In other words, the legislature specifically chose to highlight a statute of limitations for certain claims, such as the Whistleblower Protections Act. There's a 90-day statute of limitations to bring that claim within the statute. ELCRA is completely silent. So it's just governed by the RJA's general residual subsection with other civil claims. I don't see, based on the fact that the legislature, was silent with respect to ELCRA claims, there's no need to differentiate those from any other types of claims in terms of the procedural right aspect component of an ELCRA claim. And I understand ELCRA, I don't want to be confused here. I'm not disputing that the right to be free from discrimination or sexual harassment or unlawful retaliation for complaining of protected, of unlawful characteristics. Those are substantive rights. But the right itself, the timing of that is procedural right. And if you look at Camelot, which of course was overruled in terms of the reasonableness test. If you look at Camelot, even this court held in Camelot, the statute of limitations doesn't reflect the floor, it reflects the ceiling, the maximum period of time a plaintiff can bring a claim, the maximum period of time. So I don't think it's appropriate to look at the statute of limitations in the RJA saying, the Michigan legislature has said 3 years is 3 years. You can't have less than 3 years. No, they said you have up to and including 3 years, period, maximum. And in fact, they didn't really say that because, again, it's on the RJA. But if you go to the RJA, that's what it provides.
Counsel, Clark relied upon the notion that employees are free to walk away, because they at least did recognize that to have a contract, there has to be, I guess, some freedom of the opportunity to enter into the contract. I mean, is that really true that employees can just walk away?
I submit the answer is yes. I mean,
Okay,
certainly.
what if it's a recession? There's no jobs
Recession?
available.
There's obviously, it's more difficult to walk away, but an employee is free to find other employment, contract with whoever he or she deems fit. You know, that we're getting into, if we get into, you know, those types of circumstances, we're getting back into, I believe, the reasonableness type test from Camelot, which again, that was overruled by Rory. So unless we're going to overrule Rory here today, or whenever your justices issue your decision in this matter, I don't think that's an appropriate inquiry.
Can I ask, what is, I mean, and this may sound like an odd question, what's wrong with reasonableness? This whole, like, we're gonna get back into this question of reasonableness, and we don't do that. I get it, it's a lot cleaner. You can, you can do it more quickly, dispose of cases, if that, and reasonableness is factually intensive, it's, litigation, messy sort of thing. But, if we look at adhesion, what we viewed as an adhesion contracts before Rory said an adhesion contract is just a contract, it was looking at if it is adhesion, we look at the meaning of the contract, which the person, employee, insured, whatever it may be, would reasonably expect. What is the danger of looking? I mean, and I use danger as like in the world of litigation and setting law and having trial courts and judges make fact questions all the time. What is the problem with going back to a reasonableness?
I think at its core, there's nothing in and of itself wrong with reasonableness. But the problem from a practical standpoint, legal standpoint, is who defines reasonableness? How do we assess reasonableness? That's a very amorphous.
We do it all the time.
Amorphous.
The reasonable person standard is the standard that is probably the most basic principle in law.
Sure, that would be a jury question, not the judge sitting in the place of the fact finder. It's not a question of law, that would be a question of fact. Here, when you talk about contracts, you're generally talking about questions of law, I submit to the court. And in terms of reasonableness, again, I think the Rory Court, I agree with the Rory Court, frankly, Your Honor. I think it's the legislature's place, i.e. the people's place, who the constituents have elected our legislators to determine what appropriate public policy is. And if we go back to a judicial inquiry of reasonableness made by the judge, not the fact finder, I think we're basically supplanting the people's decision through the legislature with the decisions of individual trial court judges and judges throughout the state of Michigan. I don't think that's appropriate, Your Honor. But your question relates to Judge Welch's question as well. In terms of bargaining power, I don't think there was unconscionability here, and we'll get to that argument in a minute. That's the second issue that the justices have asked the parties and through their counsel to brief today. I mean, certainly there's traditional contract defenses such as duress, unconscionability. I mean, there's a traditional contract defense applies. A contract cannot be formed. It's void ab initio. So I do think there's a potential theoretical place where I guess the lack of bargaining power could be unconscionability from a procedural standpoint. I don't think that's present here. I think it's an extreme set of facts. But to be clear, I don't believe that mere unequal bargaining power during a recession or difficult circumstances renders something unconscionable or procedurally defective. So, sorry, just Kevin, I didn't answer your question. Do you have any further follow-up?
When we get back to this whole question of reasonableness, isn't what's behind Rory and the cases that did away with reasonable expectation is that there's subjective reasonable expectation, which is going to be impossible to determine, and objective reasonable expectation. And what could be more objective in a reasonable expectation of a party to a contract than the words of the contract itself?
I agree completely, Your Honor. I mean, really, plain language of a contract should control, and there's black letter law. Absent some sort of contractual defense, I mean, contracts are governed by the plain language.
Do adhesion contracts exist anymore?
Under Rory, no, because technically an adhesion contract is to be treated like any other sort of contract. In fact, I'll quote, an adhesion contract is simply that, a contract.
Does it exist outside of Michigan?
There are some jurisdictions, I believe California, may address adhesion contracts, certainly, but again, I think the source of law that we need to draw upon in evaluating adhesion contracts is the laws of the state of Michigan, not those of California or any other state, I mean, particularly California, which is notable for having extensive opinions on adhesion contracts as a state that's 40 million people, very different circumstances in life. Their constituents make decisions through their legislators, who they are elected. Conversely, thousands of miles away, Michigan's constituents or the constituents of legislators make their decisions to the legislators that are elected here. So certainly, I'll recognize there's adhesion contract doctrines in other states, but I think that's neither here nor there. I don't think that really controls or really has any bearing on what the law is in our state.
Counselor, what impact, if any, on these particular kinds of claims is there to the Sixth Circuit's decision saying in a Title VII and ADA context that they're not going to enforce the 180-day kind of rule? And obviously that's based on the requirement to go through an EEOC process, which we don't have here, and so that's different. But they're underlying a lot of the same sets of facts, right? And so is there what's the impact of that?
No, that's an excellent question, and I believe, Your Honor, you're specifically referring, I presume, to the Logan versus MGM case, Sixth Circuit case, 2019. I think plaintiff cited that in her brief after the application for leave was granted, and we addressed it in ours. I think Logan's actually a case that supports the employer standpoint. As you pointed out, Justice Thomas, the federal law when it comes to Title VII claims is quite different than state law when it comes to ELCR claims. Although we have the Michigan Department of Civil Rights, there's no mandatory exhaustion period.
Wouldn't a litigant, aren't these underlying the same allegations about what happens?
Yeah.
Might be brought in a Title VII versus an ELCR claim.
Sure, and in those situations, what I've seen happen from a practice standpoint, Your Honor, with an ELCR claim, of course, if there's no contractual limitations period, they can wait 3 years, and generally that would be sufficient, or up to 3 years, and that would generally be sufficient in my experience from the EEOC process to play out. What I have seen in other matters where there is a contractual limitations period with the ELCR claim is that they file the ELCR claim, the Title VII claim is, the Title VII administrative complaint is submitted simultaneously to the EEOC. The EEOC, not always, but more often than not, issues a right to sue letter, does not retain jurisdiction, and the plaintiff amends to include a Title VII claim. Getting back to Logan, though, the Sixth Circuit, the reasoning in that, of course, for holding that you cannot contractually shorten a Title VII, the limitations period for a Title VII claim, is that Title VII has a mandatory exhaustion requirement with the EEOC as set by Congress, which in a dual enforcement state is 300 days, i.e. a state like Michigan. So you can't waive the EEOC's jurisdiction. Obviously, that's set by Congress to investigate complaints of discrimination. So contractual limitations periods actually run afoul of an enforcement scheme that Congress has set forth with respect to Title VII. In contrast, though, you have to look at Logan closely, because in Logan, they've noted that a limitations period can be shortened for a federal claim. And specifically, they've cited, the Logan court cited to ERISA in a 1981 claim, which actually involves a claim for race discrimination. You can contractually shorten those claims. And that's where the statutes, like ELCRA, did not set their own limitations period. So again, that's the same exact situation here, situation we have here. When the limitations period for an ELCRA claim is prescribed by the general catch-all provision of the RJA, it's merely a procedural device, just like causes of action under 1981 and ERISA, which do not have their own statutory limitations period. And that's not unique to the Sixth Circuit. The Seventh Circuit has also concluded you can contractually shorten the limitations period for claims brought under anti-discrimination statutes brought under federal law. I feel there was another question I may have missed. No? Okay. So I want to get back to the public policy argument, or the first question presented, whether Clark violated public policy. Feel that it does not. When you look at the legislative history of amending ELCRA, this is not a situation where the legislature has been asleep at the wheel for 20-some years. Clark, although this court has not weighed in since the issuance of Clark has been the law of the state of Michigan since 2005. ELCRA has been repeatedly amended as recently as a few years ago. I mean, ELCRA, for instance, was amended to, admirably so in my opinion, to prohibit sexual orientation and gender expression or gender identity discrimination. They've also amended ELCRA to define race as including hair texture and protective hairstyles, yet the legislature has not done anything with respect to saying you cannot contractually shorten limitations periods.
Is that legislative acquiescence argument a little inconsistent with your prior argument that the fact that they didn't include a specific statute of limitations in ELCRA should mean something instead of relying on the RJA? I mean, in both instances, you're saying, look at what the legislature hasn't done, and with respect to the specific statute of limitations in ELCRA, you're saying that's significant, but here, the fact that they haven't amended it shouldn't be looked at.
I don't view them as inconsistent. Maybe I'm missing something, Your Honor. You can correct me after I give my answer to your question. There's silence. There's intentional silence there, clearly, with respect to not proscribing a limitations period under ELCRA, right? It goes to the RJA, which, again, is a procedural right at that point, not a substantive right. So they set a 3-year maximum. They never said anything. You can't contract lower than 3 years. Here, they've known about this development, presumably, at least under, Ford Co. versus City of Woodhaven, binding Michigan law, 2006 decision, that the legislature is presumed to be aware of judicial interpretations of existing law when passing legislation. They haven't done anything on that. So I'd say, it's one thing to have silence when you enact a statute, and then all of a sudden, years later, in 2005, there's a seminal decision that, the limitations period can effectively be no more than 6 months. They haven't done anything in 20 years, so I don't view those as inconsistent. So I'm short on time, so there's more, but I defer to the briefs on those points because I do have the second issue to get into. But I will submit, I don't think you can get around, if you can't simply overrule Clark. I would think this court would have to overrule Rory, and I think there's absolutely no basis for this court to overrule Rory under principles of stare decisis. We briefed that extensively in our briefs, so I'll defer to the brief in the interest of time, unless any of the justices have questions on those points. So moving into the second question presented as directed by this court, whether the contract at issue is an unconscionable contract of adhesion. We've touched on this briefly to some extent. Again, an adhesion contract is simply just a contract. It must be enforced to its plain terms unless a traditional contract defense applies. So I think in terms of the second question presented by the court, the true meat and potatoes of the inquiry is simply whether the contract is unconscionable. Not the adhesion label can be taken out. Is it unconscionable or is it not unconscionable? In the terms of procedural unconscionability, The plaintiff's argument is that, quote, defendant appellee as the employer had significant advantages in terms of resources, legal knowledge, and negotiating power, while plaintiff appellant had limited options but to accept the terms of secure employment. The inquiry for procedural unconscionability, of course, is that she had no realistic alternative to the acceptance of the term. And I don't think there's any facts here to support that. And again, it circles back to, discussions and arguments have been made by both sister counsel and myself. Whereas I believe sister counsel, she can correct me on rebuttal if she feels, if I've misquoted her, but there's an inequality of bargaining power that renders the contract unenforceable. I submit, again, to Justice Zara's line of questioning, if you render contracts unenforceable or procedurally unconscionable, I would say, due to mere inequality of bargaining power, that's going to invalidate all employment agreements. And really beyond that, I don't see how you can even have freedom of contract in the state of Michigan to begin with. Show me a case, and I've been doing this for about almost 12 years, so I can't say my 30, 40 years of doing this, but in my legal career so far, I have never seen a factual scenario where there has been a 50-50 split of negotiating power, of leverage and bargaining power. It's just, I haven't seen that case both in practice, academically in law school, or in any cases I've researched.
That's what I'm struggling with. I don't think that the principle of how you construe a contract that you view as an adhesion contract to be, well, was it 50-50? Is the nature of the contract, is there some unequal bargaining power? It could be 49-51, it could be 0 and 100, whatever that may be. The principle is that you're looking at the reasonableness of what that person with a lower amount of bargaining power would reasonably expect, right? And even Timika was saying 180 days is reasonable absent evidence that the employee didn't have a sufficient opportunity, that it wasn't reasonable, right? It's not this black or white. I'm struggling with this, again, I guess going back to reasonableness is something that courts do all the time. We haven't been doing it, I agree, in the contract context or in these particular contracts, but it's not something that courts are ill-equipped to do.
I would say, when you have a question of law, obviously that's the trial court's domain. When you have a question of fact, that's obviously the fact finder's domain. It's a very slippery slope, I believe, if this court is to accept the position that judges are the arbiters, the umpires of deciding what is reasonableness, of what is reasonable. And I want to, I have about 3 minutes left. I will say this. I don't believe this court should overturn Clark. I certainly don't believe this court should overturn Rory. But even if this court was inclined to do so on this matter, I think under any semblance of a legally cognizable, reasonable standard, in this case, the claims would still be time barred. And the reason for that is, in this matter, this is not a situation where the plaintiff came in to a law office 181 days after the adverse employment action. This is a situation where the employee came in 2 years and 9 months, filed 2 years and 9 months after the adverse action. So even if you establish some new rule of law that you apply retroactively, which I do not believe you should do, I do believe under any reasonableness test, the cases would still be time barred here.
What if she came in at 2 years and 9 months because she knew the legislature said she had 2 years and 12 months?
Well, again, that's setting the ceiling, not the floor, Your Honor. That is
Sure.
That is the
she
maximum.
Thought the ceiling would
Yeah.
apply to her.
I would submit she should have read her employment agreement. She should have made a board Plawicki count request earlier. She should have been aware of her contractual rights. I'm not saying she needed to rush to a lawyer the next day after her termination of employment, Your Honor. I am not sitting here and saying that today. I do respect Sister Counsel's arguments that there is an emotional component to losing your job. And as a management side employment lawyer, I am not sitting here before you today suggesting that employees should just move on the next day at the snap of the fingers. I'm not going to do that. But what I am going to say is maybe she should have done it a year after the fact. If she's out of a job and is the victim of very serious allegations in this case, I believe she should have contacted counsel sooner. I believe she should have filed a lawsuit sooner. I believe she should have made some meaningful effort to review her contract with her employer and read that and be held to the plain language of the contract as she's required to do under Rory, which has been the law of our state for over 2 decades. So, and just one other thing on reasonableness. This has been established in the, set forth in my brief, but the legislature itself has recognized that even a 90-day period to bring a claim for reporting a violation of law and then being terminated for it, a 90-day period is consistent with public policy of the state, given that it was enacted into law. So with that, Your Honors, I refer to my briefs for remaining arguments. If there's any further questions, I'm happy to answer them. I thank you for your time today and this difficult job that you have.
Thank you. Ms. Akins, you have 27 seconds.
Yep, I'm good.
Thank you.
Can I have, is it possible to get 2 minutes? I just want to be able to adequately address, and I had a couple of questions at the end. Is it possible?
Well, let's go with the time that you
Okay.
have. If justices have questions,
All right.
we can ask them.
First, she looked and she asked right away. We sent a demand letter. She asked for an employment file. This did not have this contract in it, so that happened. This freedom to contract is a freedom to violate people's rights. The hypothetical that Justice Zara gave, they get more money under that, but in the real world, they don't even get a job. So, I'm sorry. May I continue my? I don't want to go over my time.
You can wrap up the last point.
Okay.
Yeah.
Thank you. Just to address the point of stare decisis, in Seminole Tribe of Florida versus Florida, the U.S. Supreme Court discussed what that really means. It's not a command that can never be violated. It means that if things are unworkable, the language is, or badly reasoned, then they don't have to follow it. And I suggest that Plessy versus Ferguson was one of those situations where if you don't think it fits the situation you're in now, you are allowed to revisit it. To the question that was asked about the reasonableness, yes, the problem with this argument from management side is that summary judgment is so often granted, and that is the judges making determinations of reasonableness before it ever gets to a jury to decide that you have enough evidence to say that a reasonable juror would do. So you do make these determinations all the time.
Okay. Thank you.
Thank you, Your Honor.
Thank you for
Appreciate
your
it.
argument.
Thank you.
Case will be submitted.